Welcome everyone to the weekly Challa Law Group immigration webinars. And today we are going live on YouTube. So that's why I was adjusting a little bit when we started. Welcome. There we go. I had to turn off the volume on the YouTube live just enough so I can see the sheet. And so there we go. So for all of you who've been joining me every week, I want to welcome you back. For those who are joining us for the first time, I want to welcome you too. And we started these weekly webinars about a year ago at the beginning of the pandemic, because we knew that there were a number of people that were stranded. And then it was right at the time that they had, a number of immigration proclamations and restrictions coming through the pipeline with the previous Trump administration. So we thought that this was the best way in which we could get out information and help those that are impacted by, immigration changes. So as always, thank you for joining. And what we will do is, oh, you are hearing an echo. I turned off the volume. Is it better now? Can you guys hear me better now? Good, good. Okay. So as I said, we started this to make sure that we get the latest immigration information to you and equip you with the information that you need to achieve your immigration objective. Sorry. And so, as always, we end it with Q&A, so you have an opportunity to ask questions. We request that you place your questions in the Q&A box and not in the chat box. It just makes it easier for us to for the moderator at the time of the Q&A. So without further ado, let's go ahead and get started. I know that there will be other people joining shortly, but I think today's webinar is very important, and I want us to get going to talk about all the great changes. But before we begin with that, there are different ways to connect with us. There's Facebook, Twitter, Instagram, of course, YouTube, LinkedIn, and a Telegram group that we'll tell you about momentarily. We try to make sure that all these mechanisms are different ways in which you can get the critical information you need. We may take a deep dive on a Facebook, but Twitter allows us to let you know that this new change has come up. So it just depends on, what you work with. You can connect with us in many ways. And please comment, and share the links with your friends. We love to hear from you. And we try to make sure that all these not just the webinars, but additional resources that we post on the YouTube channel are resources that can help you no matter what. So we've got information on the permanent residence process. We have information on you're an H-1B employee and you've got to change locations, how to respond to RFEs. So we try to make sure that all the information that is afforded, that you have it laid out in very clear, analytical way that you can utilize that for whatever purpose you need. But today, we're going to be talking about modifying the immigration landscape. I mean, we are, month 2 plus of the new Biden administration, but there are legacies of the Trump administration that still linger. You know, how to deal with that. There's a new Citizenship Act that was introduced in Congress. There's a Senate bill and a mirroring bill in the House. We're going to talk about the impact of that. There's some positive provisions and some compromises that were made, and maybe some additional strategic considerations that you should keep in mind. And then finally, we're going to have our Q&A, where we're going to be able to answer all your questions on your immigration concerns. So let's get started. Modifying the immigration landscape. Like I said, we have the vestiges of what was left over from the previous administration. If you've been joining me previously, you'll know that I've talked about how towards the end of the Trump administration, they, just overloaded a lot of policy changes that are in the USCIS policy manual, knowing that the administration would change and hoping that they would not get time to really address those changes. And they had introduced a number of new rules and regulations. So what about those? So reversing the previous administration's policies, executive orders that repealed prior executive orders. So we're hoping to hear an executive order that repeals the proclamation of the prohibition on entry of visas, but we haven't heard that yet. And I have been a biggest spokesperson to try to make sure that that gets front and center and addressed. The congressional review look-back provision allows rules issued during a 60-day look-back period available for review by Congress. And any new rule through the APA, they can publish the rule, repeal it through notice and comment. And there is something called the delay midnight rules, effective dates through the temporary review of all regulations, and delaying litigation challenges that are part of it. So, they can use the APA, Administrative Procedures Act. All agencies, all federal agencies have to adhere to something called the Administrative Procedures Act. There are certain procedures that agencies have to follow, and it's clearly outlined what they need to do. So they could delay an effective date, they could repeal a previous rule, refuse to defend a rule and argue that the court's decision vacating the rule applies nationwide. Now, remember that there were a number of challenges to President Trump's rules, and a lot of them got overturned by a federal judge, saying that it went beyond the scope of what the agency could do. They could vacate the rule, the agency could by issuing a memo or settling a litigation, and they can challenge an agency guidance based on the unlawful appointment argument. So there's a lot of mechanisms that this administration has to address some of the concerns that the previous administration left behind, the mess that they left behind effectively. And please, if you have any questions, as I stated earlier, post them in the Q&A, and we will have plenty of time at the end of this webinar to answer all your questions. So thank you so much in advance for doing that. Now, as you may have heard, the U.S. citizenship legislation was introduced into Congress. So what does that mean? Well, there are a lot of good provisions and bad provisions. Some of the good provisions are it raises the level of employment-based immigrant visas from 140,000 to 170,000. It eliminates employment-based country caps starting in fiscal year 2022, which would be this October. So remember, immigration functions on a fiscal year from October to October. So we're currently, from October of last year, it was fiscal year 2021. So fiscal year 2022 would be in October of this coming year. Any unused numbers from 1992 through 2020 which could be close to 220,000 that would be reallocated. STEM graduates from U.S. universities, STEM PhD graduates from U.S. universities would be exempt from the numerical caps, which is phenomenal. Student visas, and this is a biggie. Remember student visas, you always had to prove that you intended to return to your home country. And if you had a green card pending, it would be a problem to re-enter the United States because it did not have implicit dual intent. So F1 students would be dual intent visas. Spouses and children would be exempted from the numerical limits of family and employment-based sponsored categories. So that would really do a lot in terms of alleviating the backlog. Permanent residence would be granted to anyone who has waited 10 years with an approved immigrant petition, not subject to numerical limits, and would take effect in 60 days of the passing of the act. The legislation also allows for extension of non-immigrant statuses beyond the limits. Remember, H's were the only ones that really could extend their status beyond the 6 years numerical limitation. So this new legislation would allow that to apply to F1 students, L1s, O1s. Legislation also, and what's great about that is that it would effectively allow, F1 students to jump over the H-1B process and go straight into green card. So that's something really wonderful to think about, especially for those who are entrepreneurs or thinking about doing a startup. This may be a great mechanism to leverage. They would be in 1-year increments until the decision on the immigrant petition. And like I said, this could allow the student to bypass the H-1B. There would be statutory protections for H-1B work authorization. Remember, it was issued through executive order during the Obama administration. So this way it would be enacted into regulation. So it would be very difficult for a future administration to simply repeal it. And it expands the eligibility to more spouses and children, including automatic extensions. So automatic extensions of EADs there were only very limited groups that were allowed automatic extensions, one of them being adjustment EADs. But with the biometrics taking so long, this would expand automatic extensions to help with the processing delays. The biggest, I think, benefit is it protects children from aging out. A beneficiary can retain the early priority date of any petition that was approvable when the document was filed. And the H-4's age at the time of the parent's immigrant petition would determine the eligibility. That's wonderful. They increase the diversity lottery from 55 to 80,000 and reduce the permanent resident waiting period from 5 years to 3 years before naturalization. That's great. The lawful immigration status, there is a lawful prospective immigrant category that creates a pathway to citizenship. It allows employment, Social Security, pathway for LPRs after 5 years, and requires background checks and fees and physical presence in the United States. But that, would help a large number of people. And of course, we've always wanted some legislation to address the issue of the Dreamers. So the DREAM Act gives a pathway for permanent residence, which includes the Dreamer's spouse and children. And then the DACA renewal becomes more streamlined. And TPS applicants. So TPS is issued, it's temporary protective status. It's a status that's usually issued by Congress when there is something happening in the home country that would preclude someone from returning back, like a major hurricane that's devastated their country, or some type of uprise, but something in the country that would make it difficult for them to return home. So previously they would just have to kind of wait for Congress to continue their TPS status. And it wasn't really solidified that they could adjust, so this allows them to adjust. An agricultural worker provision for non-citizens performing agriculture and labor services for 2,300 hours or 400 work days in a 5-year period prior to their application. Previously, H-2Bs could not apply for a green card. So there's the recapture of green cards and repeals the provision that subtracts immediate relatives. So immediate relatives would not be counted against the overall numbers, and they would lift the cap from 226,000 to 480,000. And this is all in the sense of, one of their strong overall policy measures of wanting to facilitate family unity. It would eliminate the employment-based country caps in fiscal year 2020, repeal the 3 to 10 year bars for overstays to promote family unity, and there's relief for orphans and widows and widowers in case the death of their spouse who is in the U.S., which is really important. Remember, we talked about there's a lot of frontline workers that, if anything should happen to them, frontline of the COVID vaccine, and if anything should happen to them, their children and widow, are kind of left in the lurch. So these protections are really important. They establish a pilot program for regional economic development visas. Now, this is really interesting because it's 10,000 visas annually, and its employment is essential to the economic development strategies of cities and countries which they will live or work. A labor certification is still applied. So this gives your economic development authority kind of some say or a mechanism, a tool in which they can use to grow the economy in areas that, need that extra push. And it doesn't, and this is aside from all the other employment-based categories. Actively promoting U.S. citizenship, increase in immigration judges and improve efficiencies. And they would repeal the 1-year time limit to apply for asylum and increase the U visa annual cap. Remember, U visas are for those who are a witness to certain types of crimes. And they need to get a certification from law enforcement, either a judge, a sheriff of some kind, to say that they are helpful to furtherance of this particular crime as a witness. And so they're increasing that from 10,000 to 30,000. There are some bad provisions, as I told you about. And remember, this is not final. There is going to be, it's going to go through committee. There's going to be reconciliation between, the House and the Senate. And this is our opportunity to be able to lend our voice as this legislation is being crafted. And I can assure you that there's one thing that we do at Challa Law is we lend our voice. So this would allow DHS, in consultation with DOL, to establish by regulation a procedure for limiting employment-based immigrants, EB2 and EB3, from entering the United States or adjusting status in geographic areas or labor markets that are experiencing high levels of employment. Now, the problem is when you've got a great administration, that's not going to be an issue. But if you have an administration that has some anti-immigrant sentiment already, then there are concerns that, there's a chance for abuse. And so the other problem is there's no clarity as to what the definition for high level of unemployment or temporary stall. Remember that President Trump, in issuing the restrictions on entry of certain types of immigrant visas and certain type of non-immigrant visas, actually used the economy as an excuse. And even though there was no evidence to prove his contention that it really impacted the economy. So that is what is disconcerting is there's no protections for an administration that has an anti-immigrant agenda. It contradicts Section 3202 of the bill, which limits presidential use of 212F. 212F is in the INA that allows the president to curtail entry. Really, that's all the president can do under, he's got broad authority under that. And President Trump used it to authorize the Muslim ban. That's the reason for the proclamation that limited entry or visa issuance for certain non-immigrants and certain immigrant petitions, and the diversity lotteries and others. So another provision that's not so good is they're still thinking about eliminating the random lottery and trying to do it in favor of a wage-based selection. I don't think that that's going to hold. I mean, I think, you know, if you think about it, some of the largest use of these types of visas or hospitals are, you know, research facilities, startups. So, you know, what are you trying to promote with the H-1B? The idea is to promote highly skilled, highly talented individuals to come into the US. And if you're using wage as a basis for that, then you are rewarding those people who choose to work for large companies that can provide that salary. So I think there's a lot of public policy issues with that specific provision. You know, reversing the previous administration's policies. The biometrics appointments are still being rescheduled from last year, and you know, there's still a large number of applicants that are waiting. The EAD's estimated processing time is from 7 to 10 months. Some are reporting longer waits, and AILA is now trying to collect information because they, it does not seem that everyone is being afforded, because remember, they said that they would not re-biometric someone or require the biometrics for certain people who've had the biometric done recently, but it does not seem to be applied to everyone. So they're trying to find cases to bring that to the administration's attention. They issued some guidance on students' OPT EADs, where they've stated, because that's taking about 6 months. I mean, there's so many people that are worried that you know, the job offer won't be there. So the students can remain while it's pending, but cannot work until it's approved. So that doesn't really fix that problem. The STEM OPT extensions can still work as long as the extension was timely filed. And it also included some provisions that, you know, there was some mix up with the lockbox, which lockbox it was, you know, that was supposed to be, so there's some mix up with the mailing. So they're going to excuse that. And they're also going to make sure they excuse checks, you know, that, you know, to try to make sure that the checks are stamped in a timely manner, so that, remember, if a check has been pending for a long time, it's no longer valid, which would cause further delays. So they're trying to keep on top of that. But I think a simpler fix would have been that they allow these students to work with a receipt notice, and you know, while, you know, it's getting adjudicated. But let's see, maybe that's going to come down the pipeline shortly. So additional strategic considerations as we're getting into the H-1B cap season. Remember, we said that the registration begins March 9th through the 25th. And so if you know of anyone that is in, will be filing for an H-1B this year, make sure that they're alerted to the timeline and what needs to be done. So the Supreme Court is going to hear arguments on the public charge rule. That's that pesky 944 form, which was ridiculous. It asked about, you know, all your assets, not only for yourself, but for your spouse and even your children. So it's all because of the public charge rule. So it was blocked by the 7th U.S. Court of Appeals, and dissenting ruling was the then Judge Amy Coney Barnett. So she dissented, and she's now on the Supreme Court, who will hear the case, who found the rule was a reasonable interpretation of the public charge. And as I talked about, ALIS trying to put together some stats to provide the administration about the delays in the EADs and the arbitrary application of allowing previous biometrics. The U.S. Court of the Second Circuit decided that the Freedom of Information Act requires the Board of Immigration Appeals, that's the nation's highest immigration court, to disclose its opinions. That's really important for attorneys, because once we see what the decision is and how they're ruling, it gives us a better sense to recalibrate and put forth new strategies with that in mind. So the BIA currently consists of 23 judges that issued approximately 30,000 decisions. And unfortunately, only 20 to 30 of those decisions are ever posted online. So that's about 1%, so a fraction of 1%. So, and those, like I said, decisions are really important because it has some precedential effect. I mean, it gives some precedence, and it allows us, like I said, to recalibrate. We're always looking at the AAO decisions, which is another appeals division, especially of petitions that are filed with the INA. And based on those decisions, we're able to retool our strategies and petitions to yield a positive result for our clients. It's really important that you stay on top of that, because sometimes it's not through rulemaking, but it's through these agency adjudications that you really see what they're thinking about and how they're going to rule. So that's really important. The USCIS announced that effective March 1st, 2021, it will revert back to the 2008 civics test for all the applicants who filed for naturalization before December 1st, 2020, or who file on or after March 1st. So if you're thinking of filing your naturalization test, you may want to wait till after March 1st if you haven't filed it yet. For those people who filed, between December 1st and March 1st, you can choose either of the tests. All interviews are scheduled after April 19th, 2021, will be given the 2008 test, regardless of the date they filed. So crafting your immigration strategies, this is a lot that we went over today. A lot of changes that are coming down the pipeline, not finalized yet, but there are changes. And so they're going to be, as we see this roll out, a lot of strategic considerations in terms of what can you do now to benefit from these changes that are going to be taking place in the future. So stay tuned with us. I think we will try to go over some of those strategies next week. The regulations just came out, and I know that throughout today's webinar, I've talked about what are some key considerations, but I think we will unwrap that a little bit more going forward. And so now next it's time for our Q&A where we will answer your questions. And please make sure you keep the questions in the Q&A section and not in the chat, because it makes it easier for our our moderator to make sure that all your questions get answered. And as I told you earlier, we have something called the Challa chat forum. Now, if you have never joined our Challa chat forum, I'm sure my team will send you out the links for all our social media. But the Telegram group is a group that people talk about their experiences. And it's really helpful for me because I can see the challenges that you all are facing, and then we can be your advocate. You know, we have a voice. I'm on API 100, and I'm on their immigration task force. We also have resources within Congress. So, you know, we'll be able to convey that information to them, because when they're writing legislation or making changes, it is not always, they don't always recognize what the intent is, what exactly the application is. So this is a really great way that I can hear about your concerns and be your advocate in that manner. Again, there are different ways to connect with us. Please connect, comment, subscribe, share it with your friends. As I ask everyone every week, share it with 5 friends, or even share it with 3. But share it so we can have a strong voice. I mean, there is strength in numbers. And so I think it's important for us to create a large enough voice so that you can be heard and changes can be made. We have visit some of our previous recordings, and we're always updating it with recordings that are not included in our webinar. So if you haven't subscribed to our YouTube channel, please do. And like I said, share that with your friends or on your Facebook. We would really appreciate it. I would really appreciate it. And if there are any additional questions, or there's a particular topic you want us to cover, please email us at info@challalaw.com. I always say info@challalaw.com because info@challalaw.com goes to several resources in our firm. So we can make sure that your questions are responded to in a timely manner. So please email us. We'd love to hear from you. And let's now get to the Q&A time. And we have with us Shekhar Challa, who's going to be moderating. As always, welcome, Shekhar.
Good afternoon, Lakshmi. Thank you. Hello, everybody. I hope you're all doing well. And thank you for the suggestions from some of you about, having this webinar put live on other media. So today we have it live on YouTube. So I think the link is not there on the chat. Maybe it's already there. We will have the link in the chat, and you can, convey this to your friends and family, across the world. Probably can watch now. And then we will continue to have on YouTube as well as, other media like Facebook and all that. So appreciate the suggestions, and let us know how the live went on YouTube. Okay. All right. Let's get on to the questions. First one is from an AA. It says, Madam, any update on when H4 delays will be resolved?
Well, AILA is looking into some of the biometrics issues, and there are lots of groups that are pushing to try to resolve this quicker than the administration has been doing. So, and there are groups that are still going forward with the lawsuit. So it hasn't been resolved yet, but hopefully, I'm advocating for it, trying to make sure that I'm your voice, but stay tuned.
Okay. Next one is from Venkata Challa. When we will come to know the fate of the new bill? What is the tentative timeline? We know if the bill gets cleared and implemented.
Right. Well, first, what you need to know is it just needs a simple majority. There's a bill that was introduced in the House and a sister bill that was introduced in the Senate. So they're about the same. So both the House will vote on it and the Senate will vote on it. Now, you have to have all the Democrats vote for this bill. And there is Joe Manchin, who is kind of he's the West Virginia senator who we're not too sure how he's going to vote. But if he does, then, you know, even if it's tied, the vice president will be able to issue the tie-breaking vote. So it probably has a good chance. But the problem is going to be there are some provisions of this that are contradictory, or may have unintended consequences. So I think it's realistic to think that, you know, probably by, you know, April, May, you may hear. In the next couple of weeks, we will get a better sense of where it's going and any revisions or changes that take place. That's why it's important that you stay in touch with us, that you connect with us on various mediums, so we can make sure that as soon as we know something, you'll know something.
All right, next one is Prem Pathak. I feel all these changes are too optimistic given there is no GOP sponsor to this bill. So apart from this bill, does Biden immigration has other plans similar to DACA for aging out children?
You are in fact incorrect. I respectfully say that you're incorrect. The support for reducing the backlogs is resounding from both parties. In fact, you had Rand Paul, who is probably, I mean, I don't think I've ever agreed with Rand Paul on anything, and he's supporting this. So there's a lot of bipartisan support for reducing the backlogs. And so I think it has a very good chance. It's the other provisions that I think you've got, you know, some of the more business-minded that are not going to like the wage restriction on H-1B selection. And you're going to have some conservatives that may not be crazy about the DACA and the provisions related to, you know, the legalization. So there's got to be a compromise. And so that's what's going to be hashed out in the next couple of weeks. And we'll get a better sense of where that's going. And once we get a better sense of where that's going, then we'll be able to assess when we think it will be passed. I think it will be passed. I think this is the first time you're going to have an immigration bill passed since Bill Clinton. So I'm very enthusiastic. I think it will happen. I think it's got bipartisan support. You just got to work through some of the, you know, logistics.
All right, Venkat Challa wants to know, what are the chances you think this new bill will get passed?
I think it's a good chance, Venkat. Hi, how are you? I think it's a really good chance. And I think that, you know, usually when somebody submits a bill, they kind of stick a lot of stuff in there. And the reason is, think about this, when you are, and I learned this when I moved to India, if you're getting ready to buy vegetables or something on the street, do you start off with what you want? No. If you're willing to pay 10 rupees for it, you'll say 30 rupees. Then, you know, you go back and forth. So this is part of the negotiation process. So I think the core concerns in the bill, the ones that impact you, will get passed, and those are the ones that have bipartisan support.
All right. Another next question from an AA. We do not apply for AOS for our son, but we did not apply for AOS for our son when we applied in October 2020 in DF days, because he turned 21 in December and had to change to F1 student. Since F1 was not considered dual intent, with the expected change in that area, would it be prudent to apply for AOS for him?
Well, he's already turned 21. The issue would be, does he have any, how long was the I-140 pending? If the I-140 was pending for some time before he turned 21, he would have some buyback time. So I would need some more details on that. Email us at info@challalaw.com and I can give you a better answer and maybe some strategies, because I have some ideas of what you can do.
All right, next one is from Vignesh Reddy. Thank you for doing this every week. Just a comment.
You're welcome, Vignesh.
Yeah, I appreciate it. I think that's pretty much the questions on the Q&A, unless people are a little slow.
Maybe there, I see a whole bunch of things on the
quick Q&A. Let's think. That's all I have right now. We keep waiting as they come in, or it's
yeah. And I thought, is there some hands that have been raised or
raise hands? No, I don't see anything. Answer dismissed, open.
And I guess
Okay.
all the things.
The next question is from Madhuri Prasad.
Okay. Hi, Madhuri.
Welcome. She says, hello, I'm a first timer to your weekly seminar. This is great. Thank you. She just wants to say thank you.
Well, thank you for attending. And if there's any specific topics you want us to cover going forward, please let us know. And if you liked today and you think it's helpful, I mean, this is the time that people need to engage and get involved and get the information they need. So share it with your friends, because we're going to be telling you strategies. Like I said, I'm on the API Immigration Task Force. I've got contacts within Congress. So in fact, when I first started before I went to law school, I interned for Ann Holton, who is Senator Kane's wife. And after I graduated from law school, I worked in the same law firm as Senator Kane. Remember, he was Hillary Clinton's VP running mate. So, and we know the Senator Warner and even representatives from other states as well. So we really try to keep in the conversation and make sure that we know what's going on before it happens.
I have a question coming up from Skills Up Technologies. So, hi, Lakshmi, we filed for APEAD on October 16, 2020. Do we have any timeline as planning to travel first week of April? Do you think we should get before that? Also, the fingerprinting was done on December 12th.
You may, it's hard to really predict. We're seeing numbers all over the place, so there's no set time frame, but just make sure you didn't buy your tickets, where you can't, if you're going to buy them, make sure that you've got some flexibility in your ticketing. And we'll let you know as soon as we hear of anything, of any mechanisms in which they're going to try to process these, get through these backlogs as quickly as they can. I know that we have heard that they're working weekends, they're clocking overtime, they're really trying to get through the backlogs. But it's a lot. I mean, you had an administration previously that just sat on their petitions. So keep posted. We'll let you know as soon as we hear anything.
Venkat Challa is back. He says, my son crossed 21 doing masters now on F1. Do you think any consideration for kids already aged out before the new bill?
There are some provisions in there that would allow the child to kind of leverage, their parents' priority date. That doesn't really help a lot in this. But if this bill passes, remember, your son can also apply independently of his application with you. And because if, he gets to leverage your priority and the numbers become current, right, for everybody, then he would be able to adjust on his own right. So that's something you should really think about. Now, if the I-140 was pending for a long time before he aged out, before he turned 21, then you would have been able to use some of that as kind of buyback time. But if that's not the case, because a lot of people filed premium to try to get the I-140 approved. And then what you could have done is filed another I-140 before the child aged out, just to change from like EB2 to EB3 or EB3 to EB2, even if you weren't going to use it. And that would have been a way in which you could have protected or frozen his age as well. But now he's already turned 21. So unless the previous I-140 has significant buyback time, which would put his CSPA age under 21, there's not a lot you can do right now.
Okay. Next question is from Maunik Panchal. I have applied for my OPT EAD card in November, and I have received my receipt notice from USCIS on February 11th. My starting date for OPT is 15th February, but since I have not received my EAD yet, will my starting date remain the same or will it differ? Please explain, as I'm not sure how that works.
Yeah, so you'll have to speak to your employer and your DSO and let them know that you haven't received your EAD. You're not out of status. It's not going to impact your status, but you can't work until you have the card in hand.
All right. Next one is from Shri Kumar. Once we get the GC, how long should we be with the sponsoring employer before changing the employer? Will there be any issue during citizenship if we switch in 1 or 2 months of getting GC? FYI, I've been with the sponsoring employer for more than 8 years.
Oh, that's good. That's good to hear. You just have to show that there's no set period. I mean, I think on the internet, there must be some website that's claiming you have to stay there for 6 months. You don't have to stay there for 6 months. The idea is that you didn't have a preconceived intent to agree to work for this employer just because you wanted a green card, right? So you've been working for them for 8 years, and you clearly you were eligible for portability to change employers after the I-140 is approved, and the I-45 has been pending for 180 days. So I think shortly after the green card is approved, 1 or 2 months is not a problem to change employers.
Okay. Madhuri Prasad is back. Question, could you please speak to a US citizen sponsoring their parents and strategies, pros and cons of sponsoring them while they are in US versus when they are in India, and the respective turnaround times?
Right. So there's a couple of issues with this. So I'm going to break it down until the changes that need to be made to this are addressed. Okay, so when a person enters on a visitor visa, they're supposed to have the intent to return to their home country. That intent can change. That's not a problem. But within the first 90 days of their entry, and this is something that was put in place by the Trump administration, before there was a 30, 60, 90-day rule, Trump administration changed it to a flat 90-day. So before 90 days, you can't file for changing their status or doing anything to forward changing their status in the US, okay? After 90 days, you can file an I-130 485 in the US. Now remember, because a B1 is not dual intent, that they cannot depart the United States until the advanced parole is issued. But other than that, there shouldn't be any problem.
Okay. Next question is from Nizar. Thanks for the live in YouTube. I gave thumbs up there and like in Facebook. The chat option is YouTube is not working, hence I came back to Zoom. Thank you,
Oh,
Nizar, for the feedback. Appreciate it. I think you were one of the guys who suggested to be on YouTube Live. And we will check what's happening with that YouTube chat function.
yeah, I'm trying to see
Maybe
that
we have
now.
to activate something in Zoom, or if there's some setting there that needs to be done, but I think we'll address that. But appreciate you getting back to us on that.
Yeah, I'll try to, I'm not sure. And I'm so bad at this that I'm gonna have to figure out, what needs to be done so we can fix it for next time.
Yeah, we'll figure it out next time so that that it works. We'll do a test run so that then we know.
And if you guys could help me out for next week, if you could let your friends know, and we can get more people, and we'll make sure we get that YouTube chat thing fixed so we have the because I kept it up on the side because I wanted to see the running commentary, but I must not have pressed something. If I was
All
good
right.
with technology, I wouldn't be a lawyer.
So Nizar is back with a question. One question though, for those who filed in October 2020 AOS, did they start receiving the EAD? Did your law firm receive any such case or heard from anyone?
Yes, there's some people that have, and it's not any clear process, which is why I am very reticent to give you timelines and stipulations. Some people that filed earlier haven't gotten them yet. Some people that filed later have received them. So, and that's one thing on the Telegram group that everyone's talking about. There's about 1,000 people on that group right now, and all of them, that group really took flight right before the adjustments were being filed. So there's a lot of information, not just from me, but from other people who are experiencing the same things you are. So if you haven't joined the Telegram group, please do. And then, you'll be able to hear from other people like yourself as to what the time frame is.
Okay. This next question is from Skill Up Technologies. Thanks for your response. A follow-up. I-765 and I-131 were filed concurrently. One I-765 says processing time of 4 months to 9.5 months, and I-31 processing time is 3 to 5 months. Is it likely to I-765 time or I-131 time? Thanks for all your help and support.
Yeah, that's a great question. I don't think it's going to be 9 months. I think, you can probably look to maybe anywhere from 6 to 8 months, 6 to 7 months at the latest. So if they're able to try to catch up and get through these backlogs. And but we'll, like I said, we'll keep you posted as soon as we hear anything definite.
All right, Maunik Panchal is back. I don't have a job yet. I'm actively applying for jobs. My concern is if I receive my EAD card in upcoming few days, will my start date remain the same or will it change? I'm sorry, I did not understand it clearly what you said before.
Well, you can't, your start date won't remain the same because you don't have authorization to work unless you actually have an EAD in hand, right? So if you don't have the authorization to work, how can your start date be the same? You have a status, but you can't work for that employer. So the start date will have to change. So you have to talk to your employer and talk to your DSO and let them know.
Okay. There's Madan Jayaprakash. My H-1B and spouse H-4 is expiring in May 2021. I have applied for AOS for me and my spouse and waiting for the EAD AP card, and will be filing for H extension pretty soon. And let's say that I and the spouse get the EAD AP card by June. Now, when the extension is in pending status post May 2021, he's got two questions. Can I go out of US and come back in using AP but continue to work in H-1B extension pending?
Well, you would have left the United States while it's pending. Technically, you can, but in order to do that, how the regulations have it outlined is you'd have to enter on your H-1B visa, which won't be approved unless, you can't get a new visa until your petition's approved. So it's almost a catch-22. But you should be able to do that as long as you don't work for anyone other than your H-1B employer.
All right, his second question is, can my spouse alone go out of US and come back in using AP without affecting the H-1B and H-4 status?
Yeah, the spouse, it's not a problem at all.
All right, Malik Panchal says, thank you for your assistance. That's the guy on the OPT, I think.
Oh,
Madhuri Prasad, follow up. What is the approximate processing time it is taking these days to obtain green card after the application is filed 90 plus days after a visitor's arrival? Thank you.
oh, okay. This is for a spouse, parents of a US citizen. Actually, those aren't taking too long. We're seeing those being adjudicated anywhere from, around 7 to 9 months.
Okay. And I think she says, thank you. And that's about it. And I think we're getting close to 1 o'clock. So
Yes.
there's one more follow-up from Skill Up Technology. Thanks for answering, Lakshmi. In another matter, L1A visa is expiring January 6, 2022. AOS filed October 2020. If the I-485 is not approved, when should plan to file extension to L1A? Approximately a month we should plan. Thanks.
No. So is this an extension from L1B to L1A?
Let me see his response.
If it's to change from L1B to L1A.
No, he says it is L1A to L1A.
Oh, okay. Then there's no problem. If you're changing from L1B to L1A, they're very specific timelines you have to follow before you're able to take advantage of the L1A. So if it's an L1A extension, then I would say 6 months prior to the expiration, I'd go ahead and initiate the extension.
All right, there's two questions on the chat, and I didn't pay attention as usual. Like I said, I'm looking at the Q&A box.
Right.
So let me look at these two questions. Sri Kumar, I think he asked a question on the regular Q&A, but then he's followed him. I applied 485, 765, I-31 in October 2020. My final action dates are current in March bulletin. If I get E80 AP, I plan to visit India in May 2021. If I get 485 GC gets approved while I'm in India, can I enter US using my AP?
Well, what's going to happen is, and this happens all the time. So when you enter, the CBP will say, well, your green card's approved and you were out. And so you would just explain to them. What they'll probably do at that point is maybe even stamp. That depends on whether an interview would be mandated or not. If there's no interview, because they have been waiving interviews. If an interview is not mandated, then what they may do if it's approved while you're out is just give you a 551 stamp when you enter. But it should not be a problem. People have done that in the past, especially when you don't know what the timeline is. So it shouldn't be an issue.
He's also asking if he can, use the E80 AP to enter US, or can I get the GC's FX FedEx, I guess, from friends to India and use it to enter US on GC?
Yeah, I mean, people do that too. So either way, I wouldn't prefer it that way, but either way, because they may ask, how did you get the GC if you were out of the country? Because before people would do that all the time, but there was no, database that talked about when it's approved, when the card was sent and things like that. Now everything is electronic and you can basically see it. So if you get a funky CBP agent, he may take issue with that. But when you're trying to enter on your AP, that shouldn't be a problem, even if your green card's been approved.
All right. As a question from Skill Up Technologies follow-up, I think, thanks, Lakshmi. Can L1A extension for employee and L1B for spouse be filed for extension while in US or need to travel back to India to get the extension? Thanks.
No, you mean L1A and L2 can be filed in the US. And as long as they're in the United States, they don't need to travel outside to get the benefit of the L extension. And remember, when you file the extension, while it's pending, there's the 280-day rule where they can work and stay in the United States on their L extension. So they can continue working on the L, in other words, once it's filed. But because they are dual intent, they've also got the adjustee status as well. So they can benefit from both.
There's a comment from on chat. Leonards says, thank you very much. But here is a question from Srinivas Vitla.
Mm-hmm.
My daughter aged out and crossed 21 when we got green card. Currently, her status is F1. I think he's continuing to type one after the other. So we'll just wait. I think you have, is this the last question you're taking or any more? You have time?
No, if you've got a couple more, I don't mind.
Okay. So Srinivasa Vetla. So my daughter aged out, crossed 21 when we got green card. Currently, her status is F1. How can she get green card?
Right, and that's what, well, pursuant to this legislation, there may be some mechanisms that your daughter can utilize. In addition, it depends on what she's studying. So, there may be mechanisms that she can leverage on her own. So if this legislation does pass, if the backlogs are eliminated, folks, I've had F1s where I've filed and sponsored their green card while they were on OPT, but they weren't from China or India. They were from like the UK or some other country that wasn't oversubscribed. So if we know that this bill is, on its way to get approved, she can go ahead and get started with her permanent residence process if she can find a sponsor.
All right. Skill Up Technology just wants, thanks Lakshmi and team, appreciate it. And I think that's about it. Probably people all know that we probably close around 1 o'clock. So.
Right. Well, I want to thank everyone who joined us today. And as always, I like to give a shout out to my entire team. And especially, I know a lot of you communicate with Kara. So Kara Wood, with 2 small babies, is does a big chunk of putting this together. So, let's all give a thanks to Kara. And I want to thank you, Shaker, for taking time out of your busy schedule to help moderate. I think it just makes things go smoother. Join us next week. We'll have tips every week on how to leverage this new legislation. Share with your friends. Let's get a big group going, and we'll make sure that the YouTube issue is resolved coming up.
All right, one quick, just saw the email from, that on the chat, Leonard's. So that's Christina Leonard's, Director for Immigration Compliance and Advertising, George Mason University.
Oh, hi, Christina.
Today's presentation was very helpful. Would it be possible for you to shoot me the slides in PPT format so I can brief our international advisors during the meeting?
Absolutely, Christina. If you you can either email me directly. If you email info@Challa Law, Kara will make sure
She did email to Info Challa. That's where I'm reading from.
Oh,
So
okay.
we'll reply to that email and send,
Yeah.
Tara will send the, yeah.
Yeah, so Christina, if you're still on, it's been a long time since I've seen you, so it's nice reconnecting. And we'll make sure we get you the slides.
All right. Everybody wants to say thank you. Srinivas Pushkala says thank you. Nisar says, Nisar, thank you very much, Nisar. We'll fix the chat box on YouTube before the next session. And that's about all I have. Thank you, folks. And back
Thank
to
you, Shaker. I look forward to
Thank
seeing
you.
you guys next week. Have a safe week. Have a fun weekend, and let's reconvene next Wednesday.